Okay. I've been trying to not say okay, but I do say that a lot. We're going to go over chapter 4 today, the last chapter, Ethics and Professional Responsibility. You get an entire course of it, LEX 280, and LEX 280 is required in the state of North Carolina. If you want to take the certification exam for paralegal certification, you have to have LEX 280 regardless of which degree you take. It's in the AAS, it's in the diploma, and then you have to take it for all 3 certificates too. So you have to take this course in order, LEX 280, and we go into great detail about ethics. And this is just an introduction to it. Chapter 9, the drafting assignments. I've tried to grade everything and made comments on your correspondence. And if you want to redo, you can redo it for a better grade. You have one more drafting assignment due December 6th. And this will be the last live lecture. I will log in on the designated dates and times to take questions. In the seated class, we work on the letters in class, and so I don't lecture every day. So anyways, so those are due December 6th, and there's an exam. And then there's one ethics assignment. It's due December 13th, and that's all. Then we're done. And a note about the ethics assignment. It's about, you go through a case that happened in North Carolina, and the paralegal happened to be one here in Wilmington. And about 10 years ago, she went to work. She applied for a job at a law firm, and one of my students was a paralegal there. And as soon as they were interviewing her, the paralegal said, "Ah, you were that paralegal in the ethics case we went over." They hired her anyways, but anyways, she did not like that. She did call me and email me and ask me to stop using her case. I said, "I'm sorry, it's public record." Okay, so questions? All right. Chapter 4. You always read the chapter objectives, and I'm going to start on page 86. The law profession is self-regulated, which is extremely important. I just watched my last year's lecture, and I'm basically going to say the same things, but a lot of people say that's the fox watching the hen house, if you know what that means. We're self-regulated. We try to get the best and keep the best and get rid of not the best. So the State Bar Association, the North Carolina State Bar Association, regulates. The state Supreme Court is the main regulator in North Carolina. They have the final say, because when the State Bar Association brings an action against an attorney that has done something they deemed wrong or is sued by a client, it can be, it's an agency, so it's an administrative hearing. So that administrative hearing can be appealed all the way up to the North Carolina Supreme Court. So they're the final decision maker regarding ethics in North Carolina. So ethics in North Carolina. The state legislation, lawmakers write the laws, the statutes, and we're going to go over some of those regarding the practice of law and who can practice law. And occasionally, SCOTUS, the Supreme Court of the United States, determines. And to get into the Supreme Court of the United States, you have to have diversity of citizenship or a federal question. And so the federal question here would be freedom of speech. something like that. And the case that I always refer to that did make it to the United States Supreme Court was back in 1977, Bates versus the State Bar of Arizona. Prior to 1977, attorneys weren't allowed to advertise. It was solely word of mouth, all right, which was good, I think. But the Bates sued the Arizona State Bar because he and his partner broke away from a law firm and started their own law firm for people that couldn't afford legal help, because even back then it was probably expensive. And so Arizona banned advertising, and they went all the way up to the Supreme Court, and they said, nope, it violates one of the amendments. What amendment would banning advertising violate? Anybody? Freedom of speech, the First Amendment. So states can regulate it and say what you can advertise and what you can say in those advertisements, but they can't ban it completely. They can place restrictions. Unfortunately, that's why we have all those, did you live near Camp Lejeune? You know, call me now. All those medical malfunctions, all those. Have you been injured in an accident? Anyways, my law firm the law firm I was in, it wasn't my law firm, I was a partner, in Missouri, was a gentleman, Bob Spalding, and he was old school, and he would do no advertising. It was strictly word of mouth, even though it was allowed. And I think that's more dignified, but who am I to say? Okay. On page 87, licensing in North Carolina, I'm going to talk about that, and then other states. But in North Carolina, you need a 4-year bachelor's degree in any major. Any major, doesn't have to be political science or any major. Mine were zoology and psychology at the University of South Florida, because I was going to be a doctor. So that didn't happen. So 4-year bachelor's degree, pass the bar exam. 4-year bachelor's degree, and then a Juris Doctor from an accredited law school. The law school is 3 years, so you've got 4 years under your belt, then you have another 3 years under your belt, and then you have to take the bar exam and the ethics exam. And the bar exam, before you can apply, is an extensive background check. I'm going to turn off my heater. It's getting hot. Sorry. There's an extensive background check. I had a stack of papers this high, because you have to, the information you have to give is insane. You have to give a copy of your driving record from every state that you ever had a driver's license in. And when I was 14, we lived in Florida, and you could get a driver's license at 14. So I had to start at 14. And then I lived in Missouri, I lived in California, I lived in Maryland, you know, so and then you have to get fingerprinted. They do a criminal background check, obviously. If you have a felony of more, you're not going to be able to practice law. You're not going to be admitted. There are some felonies that can be expunged, but if they're of moral turpitude, you're not going to be able to be admitted to the bar. All right, we now know that we've come a long way from only people that have a JD being able to practice law, because in several states, there's no JD required in Washington, Vermont, California, and Virginia. In California, there's something called a baby bar, and you've probably all heard that, you know, Kim Kardashian has passed the baby bar and can practice law, which is kind of scary. But also in California, I had a paralegal student who was a work study student of mine, and she moved to California, relocated, and she practiced there as a paralegal for several years. And when this law was passed, I got a request for a recommendation because she was applying to take the bar. And I called her up and I said, hey, I didn't know you went to law school. She said, you don't have to in California anymore. So now she's a practicing attorney. So I'm really proud, really proud. So California, Virginia, Wyoming, New York, and Maine all allow non-lawyers to practice without a JD if they've had some law school experience or a legal apprenticeship. And maybe that's also called an internship, which if you're for the AAS degree here, the last course you take is the WBL, Work-Based Learning 111P. And unless you're practicing or working right now for an attorney, you can take it any time. You don't have to wait until your last semester because you have to do 160 hours in on site with the firm. However, in North Carolina, only active licensed attorneys can practice law. Only active licensed attorneys can practice law. I have now gone inactive because I never want to practice law again. I love teaching. There is an exception, because there's always an exception to the rule, something called Pro Hoc Vice, P-R-O-H-A-C, Vice, V-I-C-E, which means that you can come into the state. Say you practice in South Carolina, but you have a client in North Carolina. You're not licensed in North Carolina, but you can apply to the bar to come in solely for that case. Pro Hoc Vice. So that's what you can do. You have to be accepted to be able to represent your client. Okay. All right. I'm going to attempt to share content. Oh, wait a minute. Cancel. I have to go over here first. Oh. There we go. All right, now I'm going to share my application screen. I listened to this lecture this morning and I'm saying basically the same thing, hopefully. All right, the first one is 84.4. Right? Let me see. Yeah, oh, well, we'll do that. All right, the practice of law defined. And I've taken the statute and it is updated, current one, just to make sure. You always need to check to make sure it's the latest statute. You wouldn't want to give you an attorney and repealed or amended statute. The practice of law is defined to be performing any legal service for any other person, firm, or corporation with or without compensation. Even if you don't get paid, you're still practicing law. Specifically including the preparation or aiding in the preparation of deeds, mortgages, wills, trusts, inventories, accounts, and you can read all of that, or preparing any petitions or orders for probate. You cannot assist, advise, give opinions, because that's the practice of law. Right? You can read this on your own, but I've written down here the exceptions. Paralegals can do everything listed in here when they're under the supervision of an attorney. That's how we get away with you being able to do petitions, do deeds, things like that, wills, typing up things like that, drafting letters, except not opinion letters. So any person can write their own will and appear in court to represent themselves. We know that. A person that is a party to the transfer or sale of a real estate can draft their own deed. They have to be a party. And paralegals can do acts considered the practice of law only under the supervision of a licensed attorney. And there are penalties if you practice law without a license. And persons other than members of the state bar prohibited from practicing law. Again, if you're under a licensed attorney being supervised, then you can do that. Oh, okay. Discipline and disbarment. In North Carolina, we have several discipline levels. We have disbarment, which is the most serious. You can be disbarred from the practice of law in the state of North Carolina, and you can read all this, but I will tell you what each one is, and they're listed in the order of severity. So disbarment is the worst, admonition is the least. The thing about disbarment, though, is an attorney that's disbarred in North Carolina can apply in any other state to be an attorney, and they may or may not be accepted. So you always have to check and see have they been disbarred somewhere else before you hire them. The suspension is for a period of time up to 5 years, but they also usually have to retake the ethics exam and come back after whatever period the state bar says they will be suspended. A censure is a written form of discipline. They just write them a letter and tell them not to do that again. And then it's more serious than a reprimand, but then a reprimand is more serious than an admonition. And I think that's a question on the test. Missed deadlines. If you miss a deadline and you malpractice, that's going to be probably a suspension. If there's a fee disagreement or something like that, it could be a disbarment, it could be suspension, reprimand, just how serious it is. But those are the different levels. This is the statute that allows the state bar to investigate and enjoin unauthorized activities. And this is where they talk about paralegals. Once you get your degree and you sit for and pass the North Carolina Certified Paralegal exam, you are allowed to put that on your letterhead, a business card. But if you have not been certified and you say you are, well, then you're going to be enjoined from practicing. And if they find in favor of the plaintiff, which is the state that brings the action, you shall in perpetuity restrain the defendant from doing the unauthorized. And in perpetuity means forever. The North Carolina Administrative Code also gives the DA the power to investigate unauthorized practice of law arising from the fact that any person found violating those statutes we just went over, prohibits the practice of law by persons unlicensed in the state, they may be found guilty of a class 1 criminal misdemeanor, and the punishment is 1 to 120 days in jail, and then you better not do it again. But again, paralegals are covered as long as they have a supervising attorney. All right. Okay. State Bar website. Let's see. The State Bar website has disciplines listed. Yesterday it kept spinning and spinning. I couldn't get it to come up, but I always recommend when people call me and ask for a referral to an attorney. Yeah, it's still spinning. Oh, there we go. All right. They call and ask me, to recommend an attorney. I don't do that anymore because now there's a tort called negligent referral, and if I gave someone an attorney's name and they use that attorney and they didn't like what happened with that attorney, I could be sued for negligent referral. So I don't do that. I say go to this website if you're in need of an attorney, and you go and you look at what's going on. And here we have one from Wilson. Let's see if we have any from Wilmington right now. No. Oh. Ooh. Tom Goolsby. And you can see, oh, that's a recent one. There's a complaint. North Carolina State Bar brings it against him. During the relevant periods, he was practicing law. He was defendant employed by Robinson and his law firm as his paralegal, and notary. Should have read this one before. Okay, well, I don't know. I didn't read this one, but y'all can read it and see what happened. It looks like there was a paralegal involved. Okay. Oops. But anyways, that's where you go. Oh, and you can go check them out. And I always encourage or brag that I'm admitted to the bars in California, Missouri, and North Carolina, and there's never been anything. I should knock on wood, filed against me. Okay. This is the same website, but just another link. And this takes you to the rules of professional conduct for attorneys that you, as a paralegal, must be able to read and be knowledgeable of. And they go through them: competence, diligence, communication, fees, confidentiality, conflict of interest, things like that. And we have the canons of ethics for paralegals in North Carolina that are posted on Blackboard. And we'll be using that in this chapter. And then you also will be using that in LEX 280. So if you're not experienced with this, they will give you the rule of confidentiality. Everything that happens in the law firm stays in the law firm. First gives you the rule, explains what it is, and then it gives you comments. And they also have attorneys can write to the Attorney General of the North Carolina State Attorney General and find out. I think it's Josh Stein right now. If they have a question, I'm trying to get down to some FEOs. Here we go. So when ethics opinion notes, they used to be called Code of Professional Responsibility, but now they've changed to ethics EOs. And sometimes an attorney will write and ask, can I reveal information that's confidential? And they write back, yes, if it's impliedly authorized by the client, something like that. So you always look to see, here we go, formal ethics opinions. That was in 1998, and this was the FEO for opinion number 5. Opinion rules that a defense lawyer may remain silent while the prosecutor presents an inaccurate driving record to the court, provided the lawyer and client did not criminally or fraudulently misrepresent the driving record. That was a really specific question. Usually they're more general, but that's where you go to find out the rules for attorneys, that paralegals must be familiar with them. Here we have, how are we doing on time? Okay, here we have the North Carolina Paralegal Code, and this doesn't have any notes on it, but I have written notes to help you go through it. We're going to go over it. And generally the numbers correspond to the rules for the attorneys, but I'm not going to say that they all do. So this is the North Carolina Paralegal Code of Ethics and Professional Responsibility, and it gives you a preamble, and you have to read it. And this is where it will tell you that the paralegal has a special responsibility for the quality of justice provided, and he has to work underneath a supervising attorney. We need to be competent, prompt, and diligent. You also have to know the rules of professional conduct. Those are the ones we just took a peek at. And you must keep in confidence any information, except when there's exceptions, because we know if there's a law or a rule, there's going to be multiple exceptions. The paralegal should possess integrity, professional skill, dedication to the improvement of the legal system. That's why I encourage students to write your legislatures to try and change some of these crazy laws we have, or to make another law, or to make life easier. Okay, we're guided by your personal conscience. And when I was in law school, Professor McKibbins, my contract professor, the very first day, he stood up there and said, never do something today you don't want to see on the front page of the newspaper tomorrow. So that's a good one to live by. Also, what you wouldn't want your mother to know. Never do something. All right, so you can read the rest of this. I just want to get into specifics of the Code of Ethics and Professional Responsibility. Canon number 1, maintain a high level of competence. And how do you do that? Through education, training, and work experience. And once you are certified, you shall participate in continuing education in order to keep informed of current legal, technical, and general developments. And here we go. Competence. A paralegal shall perform all assignments promptly and efficiently. If you miss a deadline, it equals malpractice. And I've been a little slack with people trying to catch up or do something, because we've had COVID, we've had all kinds of things. But I normally do not accept things late. I do give exceptions, and I totally get everyone has a life. But I'm trying to teach you that if you miss a deadline, your attorney can be sued and disciplined, and you can lose your job. So deadlines are huge. The day you get an assignment, or the day it opens on Blackboard, you mark it down and you try to get it in a week or two early. But you miss a deadline in practice of law, it's malpractice. Okay. Now, in the book, they do them in a different order. Okay, so on page 93, they go to confidentiality. So that's number 5. A paralegal shall And it says shall, doesn't say can, shall preserve all confidential information provided by the client or acquired from other sources before, during, and after the professional relationship. You can never reveal confidential information, is the general rule. All right, there are exceptions. If the client signs an informed consent saying you can reveal this confidential information, if it's necessary, if the information is necessary, it's implied authorization to represent in court. Say we have a divorce and someone's asking for alimony, and in order to for someone to receive alimony, they have to be the dependent spouse, the other spouse has to be the supporting spouse, and so we're going to need financial, we're going to need tax returns, and if we need it to represent them in court, we can reveal that. We can show the judge and put it in the record, the financial records, so that they can decide how much alimony. So the other time, let me see if it goes down here. Oh, here we go. Paralegal may reveal after full disclosure with the client's written consent or when required by law or court order. And here's one: when necessary to prevent the client from committing an act that could result in death or serious bodily harm. If your client tells you, I just killed my wife, you cannot say that. You cannot reveal that. You cannot share that, because we're going to try to prove he did not. All right. But if he says, I'm leaving this office today and I'm going to kill my wife, well, then he hasn't done it yet. He hasn't done it yet. So you can reveal that confidential information, and if his actions, if you truly believe he felt that he was going to leave, he had a gun in his hand, he left your office and he's going to kill his wife, you can obviously reveal that. So, informed consent, impliedly authorized to use during court and to prevent harm. If the client is now suing the attorney and we have proof that we were right, then we can reveal anything that would help us win our case. He's saying disputing fees or something like that. And we said, nope, here's all the records, here's everything we did. And we're trying to just bill him what we did, and he's not wanting to pay, so we can reveal the records for that. Confidentiality extends to conversations overheard by others. Don't talk around third parties. Never discuss a client in common areas of a building. Close your door when you're talking, interviewing a client. There was a case when I first moved here in 2003, maybe it was 2004, that there was it wasn't a murder trial, but it was a criminal trial, and they break for lunch, and unfortunately the defense attorney was having lunch, didn't realize it, and the same little place across the street from the courthouse that the jury was in, and he was laughing and bragging that he's really got the jury convinced that his client wasn't guilty, and stated he was so guilty, it's just and the people on the jury went back in and told the judge, they had to tell the bailiff to tell the judge that they had heard that his client was guilty. Well, that was pretty bad. The other way you can breach confidentiality is electronic communications. Cell phones are not secure. Even when you're on your office phone, keep your door shut. Most attorneys will use encryption. Yeah, not most, some in their emails, because that's certainly not private. Open files on your desk. When another client comes in, you always close any file on your desk, or better yet, if you have a conference room, you go into the conference room and talk to them, so there's no chance that they'll be seeing anything else about anybody else. Your computer screen. You've got to be careful that your computer screen is not seen by someone in your office. There's confidentiality, and then there's the attorney-client privilege. Confidentiality is a rule of evidence and work product, something that only the client can waive. And it arises upon the first contact with the client, whether or not the client hires you, whether or not you get paid. Confidentiality lasts forever. You take it to the grave, which is really, I think, a disservice, because there's many people that have gone to jail for crimes they didn't commit when an attorney knew that his client had confessed. But another client, not the one that went to jail. So you've got, and we get more into that in the 280 case, but you can never breach the confidentiality. So take it to your grave. But we need to lighten up on that. And if it can keep someone out of jail, and I'll go ahead and tell you the story that I tell in LEX 280. I still have the article where a man was in, I think, 20 years in jail. And the defense attorneys knew that this other person who was in jail also for another crime had committed that crime, because they had him write it down, and he put it in, and they kept that in a file, and he made a full confession with only information that the perpetrator would have known. And when that person that really committed this other crime passed away, the two attorneys had retired, but they came out and they tried to get it before a judge in North Carolina, saying that we have information now, he's dead, it won't harm him anymore, to let this man that's been in jail for all these years go free because he didn't do it. And the judge said that he would hold them in contempt if they said anything, and they went ahead and did it anyways. They just had to. They'd held it bottled up all that time, and it was in the handwriting of the person that really did commit the crime, and they were going to be sanctioned. Anyways, I think I have that posted in Blackboard in 280. I'll see if I can send it over. But they did it anyways. So there should be some restrictions. It shouldn't be last forever, take it to the grave, when it can help someone else. Okay. All right. Where are we? Conflicts of interest. Canon number 6. Conflicts of interest. You owe a duty to your client to not have any conflict of interest with another client or another client, to be able to represent them to the full extent of the law. And this is Canon 6 in paralegal, and Rule 1.7 and 1.8 for attorneys. And so we always do a conflict check to see if we have any conflicts when we take on a new client. And that is why you should keep a list, if you're working in a law office, of all the clients you've represented in case you ever leave, or files you've worked on. In case you leave and go to another law firm, they need to have that list to make sure if they take on another client that there's no conflict of interest. It's called a conflict check. Now, there is something we can do with a conflict of interest. If that does come about, we can build what's called an ethical wall, like on a cone of silence, if you will. If you remember Get Smart, you guys probably weren't even born, but it was they come down with the cone of silence, where you wall off the person that has the conflict, make sure they don't see the file, make sure they're not around when the client's there, and of course the client has to sign that they still want this law firm to represent them, even knowing that there is someone there that might have a conflict or no information that he wouldn't otherwise know. Right? So, such as you can't represent both a husband and wife in a divorce because they have conflicting interests. A real property, you can't represent both the buyer and seller because they have conflicts of interest. If two criminals commit a crime, co-defendants, you can't represent both of them, because what if one points the finger at the other and the other points the finger at the other one, and what are you going to do? So paralegals shall avoid conflicts of interest that may arise from previous assignments or appointments, whether for a present or past employer or client or as a public officer. So keep a list of clients. In order to be able to determine whether an actual potential conflict exists, the paralegal shall create and maintain an effective record-keeping system that identifies clients, matters, and parties with which the paralegal has worked. Here's one where you cannot enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or any other pecuniary interest. If you know that you're representing someone in a divorce and you know that they're going to have a fire, they have to sell their home, you can't go buy it at a reduced rate, or you can't share that information with anybody. You can't take advantage of your clients. Okay, how are we doing? All right. Okay. Here's one that I've stressed since the beginning, that a paralegal's title shall be fully disclosed in conversations with clients and in correspondence. You've got to let them know you're a paralegal, and there's no disgrace in that. It's an awesome title to have. But if they think you're an attorney and then they find out you're not, that's not going to be good. Okay. And you may advertise. This is for those that are freelance type paralegals. You can also, was a time where you couldn't be on your law firm's letterhead or anything, but you can now be with the designation North Carolina Certified Paralegal or NALA certification, whichever one you do. Oh, there's one I missed on 4. Sorry, where's 4? Oh, certainly shall not engage in the unauthorized practice of law. You're not going to do that. But what you do is under the supervision of an attorney. This one with not engaged in the unauthorized practice of law, this one has a prohibits fee splitting. When an attorney receives a fee for a case, he can't split that fee with you because that would be the unauthorized practice of law. What he can do is give you a bonus, a Christmas bonus, or certain times, but we're not allowed to share our fees with anybody. Okay. I want to stop sharing. Nope, I didn't want to do that. Someday I'll learn. No, I won't. Okay, that's basically the whole chapter. There's not an exam for chapter 4. There is an assignment on that case that the paralegal still works in Wilmington. Anybody have questions, comments? I'll stop recording.